Development Debate with me, Tamanna Inamdar. In what could be a massive setback to banks, the Supreme Court has held that a hearing must be allowed to borrowers before the classification of their account as fraudulent. Essentially, the process of banks declaring a borrower's account as fraudulent will have to include giving that borrower a chance to explain themselves, as well as a detailed reasoning for why a specific account is declared as fraudulent. This essentially dilutes a 2016 RBI circular which set the benchmark for how banks declare an account fraudulent if the loan has not been serviced for 90 days. So what was this case and why is it expected to have far-reaching consequences? To speak on this, I'm joined today by H P Ranina, advocate in the Supreme Court, Tushad Cooper, senior advocate, Mythili Bhusnurmath, consulting editor, ET Now, is with us on the show, as is Sunil Mehta, chief executive of the Indian Banking Association. Welcome to all of you and thank you so much for speaking with us today. Mr. Ranina, let me begin by getting your opening remarks on the implications of this decision by the Supreme Court, and will it also impact other borrowers who have been declared fraudulent by this process in the past? Does it open the window for them to go back and challenge those decisions by banks?
The whole purpose of this is to give an opportunity of being heard, because what the Supreme Court believes in is in the principle of natural justice. Under the circular of 2016, RBI could just declare it subject to certain guidelines as being fraudulent. But what the Supreme Court feels that simply because a account is overdue by more than 90 days or interest has not been paid, that does not make it fraudulent, because fraud involves something which is done in a manner which is not proper. For example, a man may have a difficulty in repaying the loan for genuine reasons, and therefore his loan account is not operative for 90 days. Therefore, to call it fraudulent, I think, would be a travesty of justice. And this is what the Supreme Court has said: give him an opportunity of being heard and record your reasons as to why you consider it to be fraudulent. So personally, I think it's a fair judgment, and it will certainly apply to those who are already in the pipeline and in whose cases they have been classified as fraudulent.
Will have retrospective effect.
It will.
Okay, so that's the important bit, right? You might have a situation where you're going back and unraveling a lot of declarations of accounts as fraudulent. Now, Mr. Mehta, as I understand it, the Reserve Bank of India as well as the State Bank of India in court, challenged this, because this was an order by the Telangana High Court which they had challenged in the Supreme Court, and now this decision has come in. And the grounds for that was that if we tell the borrower that we're going to declare their account as fraudulent, it's going to not serve the purpose at all. Can you explain this aspect to us? Because it seems on the face of it strange that banks would not want to give the borrower a hearing before declaring their account as fraud.
So, Tamanna, I'd like to clarify two things. One thing is, every NP account which is a default beyond 90 days is not declared as a fraud. So this is a misconception. Banks declare fraud only after adopting a proper due diligence process. And what is that process? So there are early warning signals which are generated from the accounts and the transactions happening in a particular account. Suppose that money has been lent for a particular project, for a housing project, and the promoter is spending that amount in a lottery, or they are doing diverting that fund to unrelated activities. It can be speculative activity or any other activity. So such type of transactions, when it is observed in the account, then it is considered to be early warning signals. So these early warning signals are then analyzed by the bank, and bank usually asks the borrowers, what are these transactions, how you have spent this amount, which was a borrowed money, to an area which is unrelated to your economic activity. So that explanation is sought from them before we consider it as a unwarranted transactions into the books of the borrower. After that, once the borrower's reply is not satisfactory about explanation about these transactions, then the account is red flagged. Account is red flagged means there are suspicion transactions in this account, and if the borrower is dealing with more than one bank, it can be a multiple banking arrangement or it can be a consortium arrangement, then this issue is discussed in the joint lending forum or the consortium where it is discussed that this account has got these suspicion transactions, so that the other banks can also get alert and can respond to it. After these transactions are analyzed and the bankers think, yes, these transactions are suspicion for which borrower could not offer a reasonable explanation, then they go for a forensic audit. Okay. Forensic audit goes to the money trails. Money trails that from the where the money originated and where it last ended up. And when the entire chain is established that yes, this has been siphoned off or misutilized and has been sent for a purpose other than the business, then only bankers take a call for declaring as a fraud. So there is a process of consultation with the borrower at the time of a suspicion transaction when it is before red flagging. There is a process of consultation at the consortium level also, because these transactions are discussed in the consortium with the borrower. So it's not that they are not consulted or they are not informed or their clarifications are not sought. This is already there in place, and while declaring a fraud, before when there is a forensic audit, the auditor goes and check all those transactions and those suspicious transactions. The borrower is very well aware that banking system has got certain doubts about these transactions.
No, but Mr. Mehta, if I may interject and ask for a clarification, you're saying you tell the borrower when you want to ask them specifically, why have you used the money in a certain manner, which is not in line with what was expected. Basically, you borrowed money and you're using it for something else. I'm just putting it in very simple terms. You ask them then. At that point, are you telling them that their account is being considered for a process of declaring it as fraud? Or,
no,
or do you tell them before, do you inform them or tell them or give them an opportunity to present their side before taking that final call that this account is now declared fraudulent?
So this process do happen because borrower, how do we know about a transaction? So ultimately borrower is asked about this transaction, they give their explanation, and if the explanation is found satisfactory, bankers drop that transaction. But if they found that the explanation not satisfactory, then only they red flag that account. So right now, the process of informing the borrower and bringing him on board is already there. Only thing is the judicial process of giving them a show cause, documenting the entire thing, what were their reply and where we differ from his reply, and to document that order. So this process will be add-on with the Supreme Court judgment. And I think this is a welcome step, because if the bankers will go for this process, this will definitely make two advantages. One thing is the principle of natural justice, as on which the Supreme Court has taken a decision, will be established. And the chances of a borrower going to the court on this pretext that I have not been given a reasonable opportunity will also be avoided. So this will be good for the system. So I think the judgment will not have any very negative ramification, except for the factor that the process will require a small modification, documentation of the entire process of default, its clarification sought from the borrower, and reasoning for not accepting his clarification satisfactory. These things will be documented, and then the borrower, then the bankers can go for declaration of a fraud. So I don't think this will have very long impact, but of course this will create a greater transparency into the system, and I hope that this the banking system will welcome it. There won't be any major challenges.
Okay, so Mr. Cooper, the Indian Bank Association is actually saying that they welcome it. It shouldn't be too much of a problem. Then why did we see so much resistance in court? Is it as simple as an additional sort of set of paperwork? And is that the limitation of its implications in your view?
Let me first start by telling you what exactly the judgment has done and what is the reasoning on the basis of which the judgment has been delivered. The judgment basically has relied on the principles of natural justice, which it reads into these provisions, which would otherwise render, according to the courts, it being unconstitutional, being violative of fundamental rights under Article 14, which is the right to equality and freedom from arbitrary action, the right to life, in which the right to livelihood has been read into, and also Article 19(1)(g), which is the right to do business. Now, why are these rights being relied on by the court? The first is that under the provisions of the master circular, notice is required to be given to all kinds of peripheral entities, for example, lawyers, chartered accountants, etc., who may have facilitated the loan transactions, etc. Now, the court asks that if such notice is required to be given and such parties are to be heard, then why is it that no notice should be given to the borrower against whom there would be very serious ramifications once the account is declared fraudulent, in as much as that the directors of the borrower would not be able to access any funds, the reconstruction of their companies would become impossible. So why is it that more stringent conditions which operate against a borrower who is supposed to be the principal delinquent should not be given an opportunity to show cause, and persons who are on the periphery of such transactions are in fact being given such notice? So it would clearly be arbitrary, and it would clearly be hit by Article 14. Insofar as 19(1)(g) is concerned, the court relied on the fact that if you don't give them notice, their business activities can be scuttled. And the argument of the bank that what they were doing was merely an administrative action, because what the banks contended was that we are only making a complaint as dictated and mandated by the RBI circular. This is akin to lodging an FIR. Before a party lodges an FIR, there is no question of giving a hearing. So why is it that we are being asked to give a hearing in such a case in respect of what they termed an administrative decision? The court, however, said that this is not a mere administrative decision. It is in the nature of a quasi-judicial action, and it would have far-reaching and wide ramifications on the borrower. And unless the requirements of audi alteram partem are read into the provisions of the master circular, it would be rendered bad. And they relied in this connection on earlier judgment of the Supreme Court, where it was held that such hearing must also be afforded at a stage when a party is declared a willful defaulter. So they said that if at a stage where a party is being declared a willful defaulter, it is necessary to give such notice and hear the party, this is a case which is far more serious. Surely notice ought to be given in such a case. The argument of the banks in counter to this was that, but if notice is given, then it would delay the process of reporting, etc., and would result in serious detriment to the economy, etc., etc. Public monies might get jeopardized, etc. Now, in my view, that argument is not really sustainable for the simple reason, as was pointed out by one of the other panelists on this show. Prior to the account being declared fraudulent, there is a process which takes place. Now, in the course of that process, a forensic audit is ordered. By that stage, the borrower knows very well that the forensic audit is going to throw up certain factors. So it is not as if he's being given time to do something and manipulate his affairs, etc. He has ample notice in any event. The requirement of giving a notice to the party is not that he's not given an opportunity at the stage of consultation. He is undoubtedly given an opportunity at the stage of consultation. But based on the conclusions which the forensic audit may draw, or which is then placed before the lenders forum, etc., and they take a decision, he has an opportunity to show why the conclusions or findings may be erroneous.
Okay.
Now, it may well be that that is not satisfactory to the lenders forum, but at least an opportunity for hearing has been afforded. And I don't think that that is going to derail the process by any considerable length of time.
No, so then the moot question is, and Mythili, why was this opportunity not being accorded earlier if you have to follow principles of natural justice? If you're going to declare an account fraudulent, it seems but natural that you'll ask them to explain.
Oh, absolutely, Tamanna. In fact, borrowers in India are given far too long a rope, I think, as compared to advanced countries. I would agree completely with Sunil Mehta, but where I would disagree in saying it's a welcome thing, move, because precisely because it is because borrowers are given so many chances and so many opportunities to wiggle out of any charges that the banks might levy on them, that is why we find NPAs so large in our country, why we find recovery process so low, and the entire process is consultative. So it is not as if the borrower doesn't know. The borrower knows exactly where he is heading, and the borrower also knows that the banker is suspecting of fraudulent actions. So it is not as if the borrower is taken unawares. And the reason why the Supreme Court has said this, because they are perhaps under the misapprehension that the borrower doesn't get enough opportunity. On the contrary, he gets enough and more opportunity. And the whole purpose of doing this really is to ensure that he doesn't do things like secreting away the collateral and misappropriating the collateral. Those are the kind of things which we've seen. Even with the IBC, we've seen banks are finding it such an uphill task to recover their money. And here we're talking only about NPAs. So if somebody is a fraudster, he's going to be much smarter in doing those kind of things. And as far as the idea that the Supreme Court seems to think that declaring an account as fraud leads to serious civil consequences, I'm sorry, Tamanna, our problem in our country is that the consequences in our country are not severe enough, which is precisely why we have so many people breaking the law with such impunity, because the entire legal process takes donkeys' years almost to come to a conclusion. So this gives borrowers one more reason to escape any kind of punishment, any kind of action that could be taken against them. I feel that yes, it means more paperwork for the banks. It just means more delays, and you might as well pass any amendments to the IBC. Nothing very much will change as far as things on the ground are concerned. So it's unfortunate, this development. It only gives a handle to borrowers to once again try and outwit bankers. And mind you, bankers are not lending their own money. They're lending public money. So if you do not hold these fraudsters to task, then basically you're defrauding the people at large.
Mr. Ranina, I want your response to that and the points that Mr. Mehta has also made, that it's not as if borrowers don't get ample notice through the process, or they don't get a single opportunity to, say that the decisions made are not fraudulent in nature, or why they're doing what they're doing before an account is declared fraudulent. The question is, does this dilute the process to the extent where it makes it even more difficult to nail down people who are willful defaulters, or who are, engaging in fraudulent activity with borrowed money?
It means that a little more time will be taken, because if you put before the borrower the findings of the auditor, the man who has done a forensic audit, he will be able to give a reply. That's all that the Supreme Court wants. But I only wish that this procedure, which Mr. Mehta pointed out today, could have been elaborated before the Supreme Court itself. Because if the Supreme Court was aware of this lengthy procedure followed by the banks, and as Mythili rightly says, it was a proper way of doing it, then I'm sure Supreme Court may not have passed this. Perhaps this was not pointed out to the Supreme Court about this lengthy procedure. But nevertheless, this is the law of the land now.
Mr. Ranina.
Court has taken the view, and therefore let's follow that procedure. Maybe it will take another 15 days, but I don't think it should lengthen the process any further.
No, but I'm sure, let me bring Mr. Mehta in this. I'm sure the banks would have explained this in court, because this would form the basis of arguments. And I just want to get your view, Mr. Mehta, specifically on the retrospective impact of this, because it technically opens to litigation these decisions made in the past. All of these borrowers can go back and say that I wasn't given a hearing as per the natural principles of justice, and now look at my case again.
One thing I would like to explain: whenever bankers take a call to declare account as a fraud as per the directions of this our regulator, we in the process go and file a complaint with the investigation authorities. So once you file a complaint with the investigation authorities, they don't take a suo motu decision. They also go and investigate and see whether the complaint filed by a banker is sustainable or not. So the borrower gets another chance with the investigation agencies. If they say that our caller is right, we have not done anything wrong, then they can prove their case, and the investigation agencies may not find it as a fraud. But once they find it in the investigation process, then it is already established. So cases where the bankers have lodged the complaint, investigation agencies have already done their job, and the fraud has been established beyond doubt, there is nothing to open, because you need to prove a chance where there is a scope that somebody has misinterpreted the transaction. But when it has been established at 3 layers of scrutiny, one at the layer of banker, another at the layer of there's a forensic auditor, third at the layer of the investigation agency.
So Mr. Mehta, was this not explained in court?
Well, I'm not aware about what was argued in the court, because today the judgment has come, and I have a privy to that case. But I think the banker's lawyer must have presented this.
Yes. And my question about retrospective impact: does this open a can of worms? No. A whole host of defaulters can come and say that I wasn't given a fair chance. Relook the case.
So what happens? The borrower always gets a chance at every stage of time. Like, even if when the investigation agency decides about it, that yes, the bankers have reported a transaction which is a
About
fraudulent,
now. I'm
and it has
talking,
been
sir, about now. I'm
I'm
talking,
just
yeah.
so right now. So investigations, once it has happened, and there they also file a charge sheet which again go to the court. So ultimately, the final decision on a fraudulent activity is taken by the court.
So am I to
Whether it's
understand
a
you
fraud
think
or
there will be no scope for people to go back and demand that their case be relooked at because of this judgment?
But I think there is hardly, I don't know much about any such cases where the frauds were now proved. And that shows that the system is robust. Bankers follow due processes. That's why hardly any a single case I have know where the complaint was lodged by the bankers after forensic audit, after following all these due processes, and the court has said there is no fraud. So I have not found any such case. That means process is in work, process is in place, the system is operating well.
Sure.
Only point is now there will be additional layer of documentation.
That actually wasn't my question. Let me take that to Mr. Cooper. I'm talking about what happens from here on. What happens from here on to accounts that have been declared fraudulent in the past? Doesn't this open a legal sort of, space for them to go back and say that as per the Supreme Court judgment, I did not get a chance to tell my side of the story. The act of declaring my account as fraudulent should be relooked at. Does it open that window?
Yes, Tamanna, you're absolutely correct. And that is possibly one of the reasons why the bank was so strenuously opposing this matter. As to the point as to whether or not the Supreme Court was pointed out this entire process, this was an appeal from the Telangana High Court. And if one looks at the judgment of the Telangana High Court, this entire process has been detailed in length in the judgment of the Telangana High Court. So there is no doubt that all this was before the Supreme Court and was pushed before the Supreme Court also. So we haven't read the Supreme Court judgment, but it is clear from the Telangana High Court judgment that all this was actually raised and argued. On the retrospective nature of the judgment, it's an interesting point which you have raised. It is possible that the borrowers will seek now to challenge actions which have already been taken in the past. It is also possible that that action which is sought to be now challenged may be rebutted on the footing that you did not choose to challenge this in court. You acquiesced in the process. You did not seek any grievance against the non-representation which you were afforded. And therefore, today you are now precluded and stopped from raising such a contention. So this is a question which is open. Undoubtedly, it will enable the borrowers to use this as a stepping stone to agitate that issue. Whether they will succeed or not, the jury is still out. We will have to see. There was just one more point which has been repeatedly raised, but the borrower has ample opportunity. Now, on that aspect, I want to highlight that it is not correct to say that the borrower has an opportunity to represent against the findings. The borrower has an opportunity to give his explanation as to whether or not the account is fraudulent. But if the forensic auditor finds that it is fraudulent, he has to be given an opportunity to show why those conclusions are incorrect. And why is this necessary is not because of the fact that, well, he will have an opportunity and his day in court, as it's been suggested by one of the panelists. The problem is that the immediate consequence is that he is debarred from raising any money, from borrowing any funds, from effecting any reconstruction of his unit. So there are immediate and grave consequences civil to him and the exposure to potential criminal proceedings. So all this has been considered by the Telangana High Court in detail, and all this must undoubtedly have weighed with the Supreme Court when it gave its final conclusion.
Mythili, I just want your response to that. The context of whether this opens up a Pandora's box in terms of past cases, implications for future cases, and as Mr. Mehta is saying, he's sounding pretty confident that at the end of the day, because the process is so robust, it will not make a difference for accounts that have been verified and identified as fraudulent.
I would say is that an excellent law like the IBC, why has recovery been so low? Only because in our country, judicial delays are so endemic. Cases don't get heard for years almost, and the entire process, even of having a time limit, has been defeated precisely because of delays. The entire procedure is such. So this will unfortunately, especially if it has retrospective effect, be a severe setback for any attempt by the banks to ensure that fraudsters are brought to book. Believe me, when a person commits a fraud, he knows full well what he is doing. And so there is no reason to give him opportunities again and again and again, which is why, in fact, the Reserve Bank's entire circular itself, it starts by saying the purpose, and I quote over here, it says these directions are issued with a view to providing a framework to banks to enable them to detect and report frauds early and take timely corrective action, consequent action. Because as I said, this money is not the bank's money, it is the public's money. Banks are holding it and lending it on trust. When there is a fraudster, they have a responsibility to answer their depositors. So I think it is very important, and borrowers, as Mr. Mehta has said repeatedly, are given enough opportunities and more. It is not that fraud is declared overnight. A forensic auditor also, he keeps questioning the borrower. So borrower knows full well, and as we've seen, say umpteen cases of fraudsters who in fact got away from the country itself. The criminal justice system in our country is almost, like one can't say it's far from efficient. So I think it's very important that we realize and take timely action and go on appeal. Maybe the Reserve Bank should go and appeal against the Supreme Court judgment and tell the Supreme Court, as Mr. Ranina says, maybe the Supreme Court was not aware. I find it amazing that can the court make such a ruling if it is not aware? So either there is some miscommunication somewhere.
Right. No, Mythili, that's the point, and that's what Mr. Cooper said, that the Telangana High Court, which the Supreme Court is actually deciding on, has taken this into account. And obviously we don't have the details of what was argued in court. It seems unlikely that lawyers representing the RBI and the State Bank of India will not go there and tell them the process that is already in place. So that definitely is something that we can guess. What the impact will be, of course, is something we'll have to track over the next few weeks and months. Thank you so much to all of you for joining us on the show this evening and giving us a breakdown of this very, very important judgment. We'll take a very short break, but stay tuned. A lot more coming up on the other side.